Welcome to The Next Fight. I'm Don West, National Trial Counsel for CCW Safe. In today's video, we'll be talking about the first appearance in court and what happens after that. If you don't have an attorney who can meet with you prior to court and represent you before the judge, you'll probably be seen by one of the public defender staff. The public defender office is a taxpayer-supported system that provides lawyers to criminal defendants who can't afford to hire their own attorney. Sometimes the public defender will meet with everyone who's arrested to figure out what the situation is and if the case can be resolved quickly. Certainly, the public defender will be knowledgeable of the judges, the prosecutors, and the jail staff and can help you navigate the first appearance in court. If you know you won't be able to hire a lawyer, or if you aren't a CCW Safe member who will get a qualified lawyer hired for them, ask the judge to appoint the public defender. Many of the public defenders are excellent criminal lawyers. The main criticism is that their caseloads are often significant and the offices may have more limited resources than what you would want if you could pay for it yourself. At the first appearance, the judge looks over the paperwork submitted to support the arrest and that initial charge. The judge doesn't usually look at it in an in-depth way. Virtually all the cases will be found to be based on probable cause. Probable cause is the legal standard for an arrest that basically means that if the evidence stated in the report is true, it then would support a finding that the accused committed the crime he's accused of. At the first appearance, usually no witnesses testify, and the judge makes the finding of probable cause on the paperwork and then often turns to the issue of counsel. At the initial appearance, the judge will typically also address bail. Some of the people at first appearance will have a bail but can't post it because they don't have the money. The judge in that situation can decrease the bail that's on the bail schedule or can increase the bail if the person looks like a flight risk or has other issues that concern the judge. And for petty offenses, the judge can release the accused on his own recognizance or on pretrial services supervision without posting a monetary bail at all. The judge can also impose other conditions of release in addition to the monetary bail. For example, the judge can order the accused to have no contact with certain persons, witnesses, or the alleged victim of the crime. The judge can limit travel, set a curfew, prohibit consumption of drugs or alcohol, and in appropriate cases, order electronic monitoring where a GPS unit will be attached to the accused for constant location monitoring. However, if the case is particularly serious and does not have a bond amount guaranteed, it's unlikely that the judge will set bail at that first hearing. And homicide falls into this category, so it's unlikely you will get bond at this stage of the proceedings if you're accused of homicide. In many jurisdictions, the judge presiding at the initial appearance will not be the judge who's actually trying the case later on, and their procedure may require bail hearings on serious cases to be heard by the trial judge. So in that situation, a separate hearing with that judge will have to be set, and that could take several days. In other jurisdictions, the initial appearance judge will hear the bond request, but may want to set a separate hearing where testimony can be taken from witnesses and where the attorneys will have an opportunity to argue their positions. Often this hearing is set several days or even weeks away. In other words, if you are arrested for a serious offense, especially one where you used a firearm and someone was hurt or killed, expect to be held without bail for at least some period of time, several days or even a couple of weeks, until your lawyer can assemble his witnesses, confer with the prosecutor to try to negotiate an agreed-upon bail amount, and to prepare for a contested hearing if the negotiations fail. You'll be anxious, of course, to get out of jail, and these will be very difficult days for you. But it's worth taking the time to make sure you get the bail hearing right. Thanks for watching. I'm Don West for The Next Fight.